All right. The next case on our docket is 23-449. And I'll probably mess up the last name here, but is it Conde Baracol? Yes, sir. Baracol? Yes, sir. Okay, versus Jennifer Conde. So if you could approach and tell me what division of time you'd like.
I'll do the same.
Same thing? Mr. Datz?
Follow my predecessor's lead with the 2 minutes.
Okay, so 10 and 2. All right. When you're ready, Mr. Tanner.
Thank you, Your Honor. May it please the Court, Mike Tanner for the appellant cross-appellee Jorge Conde Baracol. On the main appeal, there are, again, 3 issues that key issues that we ask you to keep in mind here. And some of this relates and overlaps with the last case, but some not. I think the key issue we would ask you to bear in mind is there was absolutely no evidence presented in this case of the usual indications of personal goodwill. There's no evidence as to the wife's revenue generation, as there was with Dr. Rosenberg. No evidence of her personal relationships with surgeons. There was no testimony, as there was in the last case, that she's developed any relationships with surgeons, any referral relationships, which is not unusual. She was a very young doctor in the practice. Dr. Rosenberg had been practicing for over 22 years at the time of the sale to Sheridan. This physician had only been there less than 5 years. And the only indication, or only evidence in the record about the value the parties to the transaction put on her continued participation was the restrictive covenant payment. You brought that up in the last case, Judge. It was a factor here in the opinion of the experts, both, actually. And the parties to the transaction, Sheridan on the one hand as the buyer, and FAC as the seller, valued the non-compete at $25,000. But that's it. That's the only evidence that was presented on the usual indications. And so, well...
I had to keep your thought, but I have a quick question on the methodology. The methodology here is to say there's a covenant not to compete for 5 years. And in those 5 years, you're going to make X $100,000 per year. And at this point in the litigation, it was disclosed that the practice was going to be sold.
Right.
And she'd been under the non-compete for all but 9 months.
Correct.
So the calculation here was to say, well, theoretically, what she's been being paid is under the non-compete, and she's being paid. This is goodwill, personal goodwill to her, and therefore, with only 9 months out of the, was it 60 months?
Correct.
9 divided by 60 times.
It's 15%.
Yeah, something like that's the methodology here.
Yes.
Okay. And is that, you're not contesting the methodology?
Oh, we very much are. Yeah.
Okay, so you're saying that methodology is just impermissible in a Florida court?
And here's why we're contesting the methodology. The assumption, the basic assumption in what you just described is that the entire payment she received for her interest, the entirety, was personal goodwill. Unlike the last one where it was half, this expert testified that everything she received for her interest in fact was personal goodwill, and then he took 9/60ths of that, which was post-petition, and credited the wife with that. And so, but the fundamental problem there is crediting her with the, or treating the entire sales proceeds as personal goodwill.
I guess I misstated it, because I was a moment ago under the misimpression that it was the revenue she received over the 5 years, but it's not. It's the $2.7 million.
That was her payment, yes, sir.
That was treated as overall personal goodwill for all 35.
Yes, okay. That's correct.
Thank you. Now I'm on track.
And so, okay, well, not that, I don't think you were off track.
I was, but go ahead.
But kind of that leads me to the second point, which is because there was no evidence of those usual indicia of personal goodwill. The trial court was forced to rely, and did rely exclusively, on the testimony of the expert, on the opinion testimony of the expert witness there, who, as I just said 100% of what she received was personal goodwill. And the foundational, we called it in our brief, foundational error, factual error, was his testimony that he said he thought the parties to the transaction, again, Sheridan and NFAC, had taken all of the enterprise goodwill, all of it, and put it over on Medibill, which he described as the operating entity. That's where the operations of the practice reside. And that was, and from that, then, his entire formula took that, assumed then that all of that there was no enterprise goodwill in NFAC, and from there he developed his formula. And we say there was absolutely no evidence that Medibill, in this record, was an operating entity. The only evidence was in the stock purchase agreement. It's in section 5.12, where it's a owner of real estate. It's an inactive entity. And again, the testimony of Dr. Rosenberg, who'd been in the practice for over 20 years, said without contradiction that it was a dormant entity at the time. And so we know that this is just classic Ipsy-Dixit. And I wrote down the definition of Ipsy-Dixit because I've never had an opportunity to use that in an oral argument. But
I had to look that up too.
yeah, but the definition of Ipsy-Dixit, and it's used frequently in challenges to expert testimony, is a person's assertion without relying on any authority. And that's in the Guantanamera case, and it's in a number of others. It's taken from a U.S. Supreme Court citation, but undoubtedly that's what we have here. The expert, in his testimony, he didn't say how he arrived at that or what he looked at to get that or where he came up with that, but we know it's just wrong, it's incorrect. And so everything that the expert did
You're
from
saying
there.
the amount of overall personal goodwill is wrong, or the division of 9 divided by 60?
Sir?
Which portion of it is?
The opinion testimony that 100% of the sales proceeds that she received as personal goodwill is based on a fundamental factual misunderstanding.
Not the 9 divided by 60 fractional amount? Or
Well, he said that was a judgment call, and as we said in our papers, I'm not sure that satisfies, I don't think that would satisfy Daubert, to just say, well, there was no testimony that was pursuant to any kind of accepted methodology. He didn't offer any basis for that other than to say that was his judgment call in doing it that way. But again, we don't think you even need to reach that question because the factual underpinning of the opinion is demonstrably wrong. And so, but what we will say is that maybe with foresight, the expert was hired otherwise to do an allocation of the account where they put those sales proceeds, because there were withdrawals from the account over time by the husband and by the wife, and sometimes jointly. And he allocated those between the two parties based on the purpose of the withdrawal. And we have no disagreement with that. He did an alternative calculation where he put back in the personal goodwill allocation, or eliminated that, I should say, and treated the entirety as marital assets, divided it, of the proceeds, divided it 50-50, and then did his analysis of the withdrawals. And that alternative calculation is in the record at R3819. R3819, and we submit that is an accurate calculation of the parties.
So how did Mr. Schultz's, your expert, how did his approach differ?
Well, he took an entirely different approach. He approached it from quantifying the value not of the marital interest, but quantifying it from the other side. What is the value of the personal goodwill interest? Ultimately, you could get to the same spot, but we're not here asking you to accept the testimony of one expert over the other. We're simply saying that the testimony that the trial court relied on is not supported by competent substantial evidence.
Would it be retried if it
Yes.
were remanded?
I think you'd need to
And you use the methodology from the first case today.
well, that would be up to the trial court, of course, but certainly you can't use this one. Okay.
But just as a clarification, you do say in your brief that the husband's expert said his allocation of the account between the husband and the wife was nearly identical to Mr. Wiggins' allocation, except for the
Oh,
personal
that.
goodwill.
Yes, sir. Okay, I'm sorry, I misunderstood your question. As what that referred to was the calculation of the withdrawals from the account and who those should be assigned to.
Okay.
Though, that was identical.
Okay.
Okay, and so, but again, the numbers that are 3819 are good numbers for that purpose. And I'm going to move on then from that issue unless there are further questions from the panel on the first issue in the main appeal. On the second issue in the main appeal, we submit there were 2 points that are just undisputed in the record. One is that the startup business, the V3 startup business that the husband began, that it had no value at the time of the final hearing. The husband's expert testified to that. The wife's expert testified to that. Startup businesses sometimes are successful, sometimes they're not. But the testimony here was that there was no value to that all of the investments had not generated any value in that business. And nonetheless, though, the trial court assigned the full amount of those investments, and the amount was $454,000, assigned that as an asset to the husband.
Can I ask you a question?
Yes, sir.
You said the investments, there was no value to the investments. I think what you're saying is the investments generated no revenue, which would have been the value.
Well, that would be one way to quantify it. That if the investments had purchased an asset, for example, that there was a hard asset there that you could say had value, that might be value independent of revenue. But the kind of detail Your Honor is getting into, revenue versus assets, the testimony didn't address that. The experts simply said there was no book value, net value to the business at the time of the final hearing.
I'm sorry to interrupt. Couldn't the trial court have just made the practical conclusion that husband's endeavor did not succeed, did not make the kind of revenue to cover the expenses, but that's on his ledger, meaning the husband's, and therefore he should shoulder the liabilities and debts associated with the failed or not successful business?
Well, I don't think so, because the case law requires there to be misconduct on the part of the husband in that for the trial court to assign a valueless asset, a valueless investment, call it that, to the husband. And there was no evidence in this case of the kind of misconduct that case law requires. It requires intentional misconduct to dissipate an asset and intentional conduct that's independent of the marriage. And the usual example given are monies taken for a girlfriend or some kind of extra marital activity. Nothing like that was shown in this record.
What about the conduct of your client when I believe in the record there was at least alluded to an exchange as far as the lack of productivity or revenue from the company and your client saying, this is what I'm going to do. I'm not going back to doing what I was doing before. I guess arguably your client had marketable skills that could have been used in another employment, but he refused, or at least the records, there's exhibits in the record or evidence in the record that he refused to come off of his focus on this is going to be what I'm going to do, whether I run it into the ground or not.
Mm-hmm. Well, I don't think...
That's not misconduct.
Well, there was no finding of that by the trial court, and I don't think that fairly characterizes his testimony, Judge. I don't think he said, I'm going to do it regardless, I'm going to run it into the ground. I don't believe there was any testimony like that in the record. The points you just made, the trial judge did take into consideration in imputing income. So the trial court absolutely took that into account prospectively. What we're saying is that retrospectively, the things that had already been invested in the company, absent some evidence and finding by the trial court of intentional conduct, some sort of mismanagement that was intentional, that he started this business with the intent of dissipating family assets. And it's just improper under the cases that we cited for the trial court to have put that asset in his column. On the second issue in the main appeal, The third issue, I should say, on the M&M Bank loan, again, this was a loan that was taken out by the parties more than a year before the petition. They used it in part to fund up the startup business, and they used it in part to pay expenses. The wife, who is a trained physician, signed the loan documents voluntarily. She did say, Your Honor, that she was uncomfortable at the time about the amount of money they were investing in the startup, but she did sign it, and she acknowledged that in her testimony. And so it was a legitimate obligation of hers, which the trial court then took from her and put on the husband without any evidence of any of the factors that would justify that, and no findings in the final judgment about that. She, she certainly had the prerogative at any time in the marriage to say, we're not going to invest any more money, any more of our assets in this startup business, and anything you invest from this point forward is on you. And that point did come. And you'll see in the allocation, there were later withdrawals by the husband from their account, which the expert witness put into the husband's column, and we don't challenge those. But this was before that. The testimony was that the wife supported the husband starting the business. As time went on, she became more reluctant about it, but she signed the loan documents at a point in time where she was still, perhaps reluctantly, but still on board with the idea that he was going to use this money to start this business. And, it's a fact that sometimes startup businesses do well and sometimes they don't, but lack of success in business is not intentional misconduct, and I know we're bleeding back into the other issue a moment there, but the M&M loan, I think, is related to that because the funds there were also taken out primarily to fund the startup business. So without evidence of misconduct and without any evidence that would justify the wife, who signed the documents voluntarily, relieving her of that obligation, we submit the trial court abused its discretion on that point. And unless there are further questions from the panel on any of that, I will rest on our papers.
Okay.
May it please the court, I'm Lawrence Datz on behalf of Jennifer Condi, the appellee, cross-appellant. And I guess I'll dive into the issue of goodwill because that's been at the forefront of all the arguments. To get to the appellant's argument, the husband's argument on appeal, they have to completely ignore the detailed testimony and exhibits offered by Don Wiggins, who was the wife's expert before the trial court. He gave detailed testimony, and in fact, I'm getting a little bit ahead of myself. In Thompson, the Supreme Court said that the determination of goodwill is a question of fact for the trier of fact to be determined on a case-by-case basis with the assistance of experts. So the way this stuff unfolds is, the attorney contacts the expert and says, we got to prove the fair market value, we've got to isolate personal goodwill from business goodwill, and the expert determines the methodology. That's exactly what happened in this case. The appellant's argument completely ignores Mr. Wiggins' experience with this type of transaction, which he testified about. His explanations, the analysis of documents. He talked about looking at the flow of funds document, the wife's 2016 employment contract with the non-compete, interviews with people involved in the transaction, an office manager, which is a little misleading. The lady has an MBA and very intimately involved in the transaction, and an accountant involved in the transaction. Then Judge Day, in announcing his ruling, and I found a typo in my amended initial brief. I referred to the announcement as having December 16, 2023. It was 2021. I refer to the correct year in all the other places, but I just want to make sure that was clear. But he says, he also accepts Mr. Wiggins' testimony and accepts his exhibit number 1R, which was the petitioner's exhibit 1R, where he goes through the methodical calculations for all this. So then on the subject where the appellant argues there's absolutely no evidence other than this $25,000, there was extensive testimony on it. And the judges, the trier of fact, had the right to accept or reject the testimony.
Well, is this methodology one that other experts use? I mean, maybe Mr. Wiggins has been doing it for a long time this way. And I'm talking about taking the overall enterprise value, saying it's all goodwill, personal goodwill, and then, because there's a restrictive covenant, prorating it across the restrictive covenant.
He did not testify that it was a common method. I mean, candidly, I don't know off the top of my head.
Has any case ever referred to this methodology?
No, what he did, and the way he testified about it, is he backed into it. For example, there was discussion of Medibill. He backed out Medibill. It's in the testimony. And what he got down to, and what he did testify to, is that personal goodwill and the future earnings in this case were one and the same. And so what he did was, and again, this is actually on page 141 of the July 7th transcript, the second day of trial. And he says, and the rest of it would have to be the goodwill of the doctors collectively, their willingness to accept a reduction in income, and their willingness to go along with the transaction and stay and sign an employment agreement, and their own personal reputation and goodwill. And then he goes on and he explains more in detail. Basically, that a doctor who didn't want to participate would forego, I think it was $3 million in gross pre-tax payout. And then he also explained that part of it was they had to have the same mix of doctors in order to market the practice to hospitals and clinics. And the concept here is, and I think it relates, I heard something in the earlier oral argument about an empty nest. The argument is if the buyer purchased this practice with these, doctors all having a variety of years of practice, but, presumably good doctors. And then they said, we're going to fire all you guys because you're too expensive, and we're going to go out and hire a bunch of people fresh out of their residency. They wouldn't have been able to maintain their contracts with hospitals and clinics. And that's the connection to the personal goodwill. They had to have that mix of people.
Once the doctors, in both this case and the first case, once they're under contract to provide their services pursuant to the agreements to the corporation, they no longer have any personal goodwill, do they?
I'm sorry, I didn't understand the question.
Personal good, let's say you have a medical practice that generates $100 million of revenue. A portion of that is, in theory, the personal goodwill of the individual physicians who've generated that goodwill through their efforts. So in that situation, they own that personal goodwill. Now they've sold out their entire interest in their practice.
Right.
So my question is, now that they're employees, they're not owners, they're employees, they don't have any more personal goodwill on an ongoing basis.
So, and then Mr. Wiggins' testimony was, in essence, they were compensated for that at the time of the buyout.
And I think that's what I'm trying to say, is that your theory is that they took these buyouts, their personal goodwill was bought out to some extent. They have these non-competes, which basically say you can't use your goodwill to compete against us for the next 5 years.
Right.
And his theory is that I'm going to take the overall goodwill, whether it's all of the 100% or 50% or whatever the value, I'm going to take that and prorate it over the 60 months and say that that's the allocation of goodwill.
Yes, because the concept would be is that because the individual doctor then, it's what they're being paid, not to go out and earn money somewhere else. So, and I think that's what his explanation distills to. And like I said, it was carefully calculated. The evidence is, the record is replete with the evidence. They may not agree with the evidence, but the record is filled with it.
But neither physician now has an equity ownership in some medical practice. They're just employees.
True. But the point is that they were paid to be that.
Right.
And Wiggins equated that to personal goodwill.
Right.
And I guess let me finish the probably one of their main arguments about this ipse dixit business. You have to ignore the testimony and the evidence to get to that. And therein lies the point. It circles back to Thompson, and that is that the court had the right to rely on that evidence. What they're complaining about is the sufficiency of the evidence, but it's only the standard of competent substantial evidence, and the record is filled with it.
Well, one other quick thought for both of you. If at the time the transaction occurs, and let's say both sides agreed to the overall personal goodwill amount for the physician involved. Okay, the transaction occurred, I forgot what year it was. And in the first case, it was basically you're looking at it from the outset. Here you're looking at it many years down the road. Does that matter? Does the personal goodwill, the big lump sum at the front end of the transaction, does that dissipate? Does it depreciate over time, as this case suggests, or not?
First of all, there was no evidence in the record of that, but I would just answer your question in terms of general family law concepts. That under the statute, the cutoff date for identifying marital assets and liabilities is date of filing. And also under the statute, the court has the discretion about the date of valuation to use. So in this case, the argument is that if she was paid X number of dollars to not compete, then 51/60ths of that period had occurred prior to the date of filing, and so he was saying it's just the last 9 months that he valued, as in post-marital earnings. If I could address too, this whole waste or dissipation thing on the notes, this is like taking a number of accounting and business concepts and throwing them in a blender. The parties invested, there's no question these were marital assets. The parties invested in V3 Cybersecurity, the husband's business. The investments were the amounts of money taken out of joint assets and given to the entity. Both accountants who testified, their expert and ours, acknowledged these were equated to notes receivable. Now, it's typical when people are putting their own money into a business they own, they don't exactly use formal written notes. I mean, arguably the bank statements and transfers were evidence of it all. The amounts of money were never disputed. And the husband, the testimony was like playing cat and mouse with the guy, and it's all referenced in the briefs. But he like begrudgingly acknowledged that there should be a return on the investment. Yes, it's a risky investment. If the business fails, he doesn't get paid. But if the business does well, he probably gets repaid, maybe with interest and return on the investment. It's not really any. From the accounting perspective, is this: the loans are marital assets that belong to the parties. Okay. The business owed the money back to them, and whether or not it got paid either flew or failed based on the success of the business. Okay, and that's all this was, plain and simple. So the trial judge allocated those assets to the husband because he was intimately tied to the business, and it carries over into the M&M loan, which is the third issue they raise on appeal. If one accepted their argument then a judge would no longer have any discretion to decide which assets and liabilities to award a party, because everybody should get 50% of each asset and owe 50% of each liability. Under Florida family law, it is an absurd argument. The M&M loan, in the evidence, and again, part of what happens here is they ignore the evidence in the record. The wife testified that she had complained about the amount of money being invested in the business, and so they took out the M&M loan. Of course she signed it. It's a marital liability. But the judge said, on the distribution, I'm going to distribute that to the husband because, again, the record was very clear. The husband had said that the business would repay the loan. The business had been repaying the loan, and it was 100% attributable to the business.
Was the husband intending to continue the business?
The husband, I'm sorry.
Was he intending to continue the business?
Yes. There's a whole part that wasn't raised in the appeals, but the court, and it's in the final judgment, that the court imputed I think it was about $200,000 a year in income to him because, in essence, he said, I'm going to stick with my business. I don't care what you order. You know, I want to continue with my business. And so the judge's view of it is that he shouldn't have to, wife shouldn't be paying for his post-marital efforts. And that's what happened.
What was the husband's equitable distribution, the amount approximately?
I don't have it in front of me. It was, I think the net, it's attached to the final judgment. I want to say the net was,
oh, it was close to $2 million, is that right? 1.9, something like that?
I have to look, I apologize, I have to look at the final judgment. He definitely got a substantial amount of value, and most of it, frankly, was derived from this Northwestern Mutual account where the proceeds of the sale of the practice was paid into. Which actually is a good segue into the cross appeal. He wound up, I think I have the exact figures in the brief, but I want to say he wound up with close to $1.2 million net assets. And they didn't really have any liabilities other than the home mortgage and the M&M loan. And about $800,000 of that was liquid. And our position is that the wife was ordered to pay attorney's fees when he had ample ability to pay his own. There was no counting in the final judgment, or in the judge's findings for that matter, as to he had been charging a lot of his attorney's fees, and the wife just had kept paying all the bills. So there's nothing in the record that says how much of that she already paid. But the point is that he had more than ample ability to pay his own fees. And one of the points I want to make is actually a principle of law. The Fifth District acknowledges that payment of fees can be painful, and it becomes a question of degree about when a court is supposed to do it, intervene. I had referenced a Second District case simply in all candor because I just like the way they articulated. It's probably a slightly higher standard than the Fifth District, but where they said if it jeopardizes the party's economic status. In this case, and again, this is all in the brief, that the fees at issue were less than 5% of his net worth. So he had plenty of ability to pay his own fees. Unless there are questions, that's all I have.
Thank you, Counsel.
I'll be brief, Your Honor. How much time do I have, by the way?
I see 311.
Okay, very well. Let me kind of go back in reverse order real quickly. To your question, Judge Makar, the amounts of distributions are at page 10 of our reply brief. The wife received approximately $3,046,000, and the husband received approximately $1,900,000 if you include the value of the investments in the business. On the issue of the business, counsel refers to those as notes. There was no evidence that they were notes, and if there was testimony by the experts in the case that said they were notes, I missed it. and that's my bad. I'm not sure there's a site in the brief that characterized those as notes, the investments, but it doesn't matter. The issue, the funds went into the business, and the issue we said is whether there is competent, substantial evidence and findings of the sort of intentional misconduct that the case law requires for the trial judge to be able to assign that to the husband, and we submit there wasn't. But let me go back to this issue of personal goodwill. Let me say it this way. Let me go back to Thompson is very clear, as are many other cases, that personal goodwill is goodwill that derives from the skill, reputation, or continued participation of the individual. If we accept that, then the amount of money that the wife or any of the other doctors received can't be personal goodwill because they each received the same thing. The wife, who was a brand new doctor in the practice, had been there less than 5 years, been a shareholder less than 2 years.
Did you make this argument below and preserve it?
We did.
Okay, just making
Yes,
sure.
sir, absolutely. This received the same amount of money as the senior doctors who founded the practice and who had been there for decades. She received the same thing that Dr. Rosenberg did, who was a board-certified anesthesiologist who'd been practicing for 20 years. This was a corporate sale. And kind of back to an earlier point you made, Judge Makar, what makes this case different than all the other cases is that in all the other cases that are cited in these briefs, particularly the 5th District's decision in Young, where there's no clear indication of what the fair market value or the goodwill value in the business is beyond expert testimony. And that was what the 5th District criticized in Young. Said, you know, the expert just came up with this formula to value personal goodwill. Here, though, what makes those cases different than this one is that here we have a transaction, an arm's length sale with Sheridan that unquestionably quantified the amount of goodwill value in the business. And the expert in the other case went through that in detail. He said there's very little tangible asset value in here, very little cash. Most of the business, he said, is goodwill value, and the question is only how much is enterprise and how much is personal. So we would ask you to reverse on that issue and reverse on the other issues for the reasons we said in our briefs. Thank you.
Thank you, counsel.
And counsel, if you could start just briefly by clarifying whether you agree with your friend on the other side that this case is different from all of the other cases cited in the briefs with respect to goodwill.
Yeah, I'm sorry, could you repeat that?
Do you agree that this case is different from all of the other cases cited in the briefs with respect to the goodwill issue?
I have to think about how to answer that, because if you look back at if you apply the criteria in Thompson, no, it's not different at all. The expert said, you know, this is my methodology, it's a rational methodology, and I want to point out that no one ever raised a Daubert objection, nobody ever objected to the expert's testimony at trial. These are all raised for the first time.
Maybe another way to ask, are you aware of a case that has dealt with the goodwill issue in the context of the sale of a multi-member practice?
No, sir, I'm not aware of an appellate opinion, let me put it that way. In our particular case, Mr. Wiggins testified that he actually helped broker one of those transactions in the past. And he also explained that the value of goodwill was an economic attribution compared to the $25,000 figure that was just purely for tax purposes. So he covered it all, in my view. As far as just quick rebuttal on the attorney's fee subject, and Judge Pratt, I think you had asked me, it's the last page of the final judgment. It shows the net equitable distribution to the husband was $1,941,319, and to the wife, $3,046,135. And for the point on the attorney's fees too, there seems to be a lot of confusion in the world of family law over the import, all this grew from Conakris in 1980. And the appellate opinions draw an important distinction. It is not a relative standard. So if the wife received, $1 million more than the husband and is the party in the superior position, financial position, that doesn't mean that she is required to pay the other person's fees just because she has more money. It's a function of ability to pay. And I emphasize that because prior to Conakris in 1980, it was conceivable that the party who had all the assets and income could effectively starve out the other party, and Conakris was trying to create a level playing field. And of course, all that's been incorporated in Section 6116 and Rosen and so on. But I just want to emphasize that it's really a matter of the criteria is whether they're able to pay without causing themselves significant economic harm. Thank you.
Thank you, counsel. All right, well, that concludes our first two cases for this morning. We appreciate the advocacy of both counsels. Thank you so much.